I may clarify your question is, you're not going to see companies giving to us. This is as pure of a grassroots movement as you can imagine. So we are not going to be taking contributions from companies in order to accomplish this goal. If we cannot do it, by the will of the people, then you know what? Maybe we're wrong. Maybe it's not supposed to be done. But I'm confident enough to stand out there and say, I think this is something that the people of Ohio want and will demand. And the initial support just over this weekend, I think, very much proves that there are thousands of people willing to drop anything they were doing on a weekend plan, on a Friday night, to begin this process. The fact that this was even done in that short of a period of time means we have a whole lot more interested parties in this than any company. And so, no, we don't anticipate having to use money like that. And just like Maurice said, I anticipate having the money actually used against us. I expect that in a pretty significant way.
Maurice, you mentioned before the high cost of premiums in Massachusetts. If in Ohio your amendment allows the mandates to go forward on the insurance companies, what's to prevent them from raising premiums in Ohio, particularly if there is no mandate for them to spread the risk out further among a healthier population?
Well, it's true. In a relatively competitive market, the only thing to prevent a company from raising prices is the idea of competition, the idea that if you raise your prices too high, I may no longer buy your insurance. I may buy it from a different insurance company, or I may not buy insurance at all. And that's one of the things that's gotten us to where we are, is all of the mandates in any given insurance plan in Ohio have made it more expensive than it would otherwise be to buy insurance. The restriction on intrastate markets, saying that a large insurance company can't pool risk across the country or across geographic regions, but instead can only sell insurance within state borders. That allows them to create only a smaller pool, which drives up the costs for all of us. So what we've seen along the way is that government intervention has in fact been the source of many of the premium increases through its intervention, rather than a source of premium decreases. What we have to rely upon is always healthy competition. If the government restricts the market to such an extent that that competition doesn't allow people to opt out or to shop somewhere else, then what we will see is escalating rates. And if we have price caps to attack those escalating rates, what we will surely see, and there are price caps in the federal healthcare reform, what we'll see is rationing. We'll see insurers and doctors no longer willing to provide certain services, or no longer willing to provide them as often because they can't make a profit. Whether we like it or not, the profit system is what gets them into work every day, gets them working an extra hour or two. It's what creates medical innovation, that creates a lot of the really expensive treatments that some people really need and couldn't get 20 years ago.
I just want to make sure I understood the real kernel of the legal argument here. Did I understand you correctly to say that this really revolves around the Commerce Clause? And the real nugget of it is okay, yes, the federal government is superior, all-powerful when it comes to commerce, but somebody not buying insurance is not commerce, it's the lack of commerce, and that's right where you think you've got it. That's where
That's the first way in which we think we've got them. I think we've got them a couple different ways, and this is a confusing issue. The reason it's confusing is this. A court can still find that the individual mandate is a proper exercise of the Commerce Clause, but it could nevertheless invalidate the healthcare mandate as a violation of state sovereignty. So it could say Congress has this Commerce Clause authority due to the necessary and proper clause, say, and that's what it would have to use. The best argument here is that you not buying insurance substantially affects interstate commerce, which invokes a necessary and proper analysis. And then they look at the state sovereignty and say, well, maybe this would pass under the Commerce Clause, but Ohio here has this part of their Constitution that protects the health of the citizens in a certain way, and state regulation of the health of the citizens for the entire history and tradition of the country has always been elevated above federal protection. Health regulations are an area, a domain in which states get to choose under state sovereignty. And that means Massachusetts can have mandates, and Colorado may have nothing at all, and Ohio might be right in the middle, and that creates a laboratory for experiment where we can all choose different options and see what works the best amongst the states. So the idea is it's a two-tiered analysis. One, you look at the Commerce Clause, but two, then you look at state sovereignty. And this petition changes that calculus on the latter.
Let me just go back to the grassroots very quickly. It's sort of the elephant that's in the room here, but a lot of it's bigger